don't see that.
All right, good afternoon, everyone, as you're trickling in. And we'll just give it a minute to make sure everyone that's signing in can jump on, but welcome to the Special Ed Legal Clinic. Appreciate you all being here. Just give it 30 more seconds, see if anyone else is trickling in. I know we've got a good audience today, so I'm happy to see everybody and, well, see everybody's names on the screen, I guess I'll say. I can't see you guys, but thank you for joining us. We get started at 12:03. Amy and Kristen, can you see this little green thing that says annotate? This little green pencil in the bottom left corner? You can see that? Okay. Hopefully it's not too distracting. I don't know what it's doing there or how to move it, but there's a little green pencil.
I think it's fine.
Okay. Well, thank you. I appreciate it. Well, good afternoon, everyone. Like I said, welcome to the Special Education Legal Clinic. My name is Renee Stromsky. I am one of the special education attorneys at Abdenor Weicker, and I am the Special Education Legal Clinic Coordinator as well. Thank you so much for joining us today. On our panel today, we have Kristen Hildebrandt from Disability Rights Ohio and Amy Freeman from the Ohio Coalition for the Education of Children with Disabilities, OCECD. The Special Ed Legal Clinic is a collaboration between the three organizations, AW, OCECD, and DRO. And as you may have already known just by signing up on our website, which is at lawyers4students.com/legal clinic. This is our webinar portion or our presentation or workshop portion, whatever you'd like to call it, of our clinic, where we give a different presentation every month. This month, as you can see on the screen, or as you likely know from signing up, is on bullying and harassment of special education students. Next month, I forgot to look the exact date, but we are the third Monday of every month. And if I can check my calendar real quick, I can tell you the exact date. It looks like July 21st will be the third Monday in July. So July 21st will be our next presentation, and that will be on the science of reading, and we'll actually have a professional from the Ohio Department of Education here to present on the science of reading. So if you want to sign up for that, you can go to our website that I said before, www.com or www.lawyers4students.com/legal clinic. And then afterwards, after this hour presentation, or it'll probably be about 45 minutes, we will have 4 individual guidance sessions that last 30 minutes. If you've signed up, we look forward to seeing you. If you haven't, you are welcome to sign up for those individual guidance sessions at the same link that I just said, and we can sign you up for next month or whenever works for you, but we have those available where we can provide you individualized guidance on any special education related questions or issues that you're facing. During this presentation, like I said, it'll probably be about, I want to end around 12:50 or 12:55. I have a lot to talk about for you guys today, but I want to leave some time at the end for questions as well. If anyone has anything that any questions they have that I can answer. Kristen and Amy will also be monitoring the Q&A that should be on the bottom of your Zoom screen. If you have any questions during the presentation, I've asked Amy and Kristen to just interrupt me, hopefully at a good interruption time, maybe not in the middle of a sentence, but interrupt me and I can take your question as we're going, and I'll either answer it then, or if I know that there's a slide coming up on your question, I'll just tell you, hold on 1 second, we're getting to it. So feel free to ask questions. I believe we also have closed captioning, and then everything's recording right now, and will be posted in the next few days, and the link will be available next to the on our website next to the presentation name for this week, as well as all of our previously recorded sessions. So that all being said, I'll take a sip of water before I dive into our wonderful topic. Like I said, today I am talking about bullying and harassment of special education students. Oh, it's going a little slow on my end. There we go. All right. So bullying and harassment, as I'm sure you are all aware, is a reality in our school. According to the National Center for Education Statistics, during the 2021-2022 school year, the most recent I could find, approximately 20% of all students, general and special education, aged 12 to 18 reported experiencing bullying at school. So that's that teenage years. Really, I was trying to find more statistics on bullying specifically, and I couldn't find too many, which was a little bit disappointing, but it truly is a reality and something that I think each of us at AW, DRO, and OCECD come into contact with a lot. And OCALI, the Ohio Center for Autism and Low Incidence, has reported their statistic is that 60% of students with disabilities are bullied in school. So that's more than half of our students with disabilities being bullied. So it is a reality and it is happening. And for many reasons, and I don't know why this is, it's probably loading slow on your end too. I don't know why it's going so slow. Apologies for that. But addressing bullying and harassment in public schools and really all schools is crucial for the well-being, safety, and success of our students. I really could go on and on about the different, I mean, bullying and harassment, of course, it can lower confidence of our students. It can make them not want to go to school, and then we're dealing with absenteeism and truancy issues. And it makes them hard. It makes it hard to focus during school, and our students deserve to feel safe in their schools, and they deserve to feel safe in their schools and in their learning environment. So it really is crucial to address bullying and harassment so that our students feel safe and can be successful at school. So today what we are talking about essentially is the Ohio Revised Code. It's in section 1330 or 3313.666, which is entitled the District Policy Prohibiting Harassment, Intimidation, or Bullying Required. Essentially, it is our Ohio statute that requires school districts to have policies. I'll actually get to that on the next slide. You can see the citation in the bottom left corner of section B of that 3313.666. It requires the Board of Education of each city, local, exempted village, and joint vocational school district to establish a policy prohibiting harassment, intimidation, or bullying. And we'll note that it specifies boards of education of local school districts. Unfortunately, non-public schools, private schools are not covered by this requirement. I will say that a lot of times that I see private schools handbooks that they do have usually something in there about bullying and harassment, whether it's policies and procedures related to, or maybe, some sort of code of conduct issue where they will implement discipline on a student who is engaging in that activity. But really the law is focused on public schools. So that includes, of course, our local school districts, as well as any community and charter schools as well. But the state law requires them to have a policy that prohibits harassment, intimidation, and bullying. The requirements under this section for those policies that regard harassment, intimidation, and bullying, they have to include a general statement that says that bullying, harassment, and intimidation is prohibited on school property, on a school bus, or at school sponsored, and I should say, and at school sponsored events, all of those places. And also it has to expressly provide that there is a possibility of suspension for a student that's found responsible for any harassment, intimidation, or bullying by both physical or electronic acts, or in-person or electronic acts. The policy that the school district or charter school has to have must include a definition of harassment, intimidation, or bullying. I really should say and there, I believe. I have a definition of all three, or kind of encompassing them, and we'll get into the definitions of that in a little bit. The policies must also include a procedure of how to report any of those prohibited incidents, and a requirement that school personnel report those prohibited incidents that they become aware of to either the school principal or whoever else is designated by the school policy. Maybe there's a student services coordinator or a compliance officer, but it must be outlined who that gets reported to in the school policy. And then there's also a requirement that the custodial parent or guardian of the student that's involved in the prohibited incident be notified that this report has been made, and to the extent provided by FERPA, have access to any written reports pertaining to the incident as well. So a little bit more of what that statute requires. Those bullying and harassment policies must also include a specific procedure for school personnel to document any of those incidents that get reported, a procedure for responding to those reports and investigating those reports. They have to have strategies for protecting victims from new or additional harassment and from retaliation. For filing such reports, including means by which a person may report an incident anonymously, if that is something that they'd like to do. If they are, too nervous of retaliation, they'd like to report anonymously. And then there also has to be a disciplinary procedure for any student that is found guilty of harassment or bullying. And then finally, there has to be included in that policy a statement that prohibits students from deliberately making false reports, and a disciplinary procedure associated with that as well for any students that are deliberately making false reports. And again, deliberately is that key word. So our definition under the state law says that it kind of lumps all three of them together. But what you'll see is that in different school policies, they kind of tease out those definitions and have different definitions, and we'll get into that in just a minute. But overall, harassment, intimidation, and bullying means any of the following. That could be any intentional, written, verbal, electronic, or physical act that a student has exhibited toward another particular student more than once, and the behavior both has to cause mental or physical harm to another student or to the other student, and has to be sufficiently severe, persistent, or pervasive that it creates an intimidating, threatening, or abusive educational environment for the other student. And then it also states that violence within a dating relationship on its own is considered harassment, intimidation, or bullying. So kind of looking at that definition, again, this is the state definition, and policies in different school districts may expand on this definition a little bit, as we'll see. And they also will usually, more often than not, they will tease apart harassment and bullying and have separate definitions for the both of them. But really, it's those any intentional act, and they specify that this is by students exhibiting those behaviors towards another student, and it has to not only cause that mental or physical harm, but it also has to be so severe, so persistent, so pervasive that it creates a difficult learning environment to the other student.
Renee, we've got a question.
Sure.
Is this information going to be specific to Ohio schools? I am in Michigan, and I believe you have services in Michigan and PA. If I'm wrong, let me know.
Yes, so this our law firm, Abner Weicker, does serve Ohio, Michigan, and Pennsylvania, but this special education legal clinic is dedicated to Ohio specifically, and I should have mentioned that during my introduction. This is an Ohio special education legal clinic. I will say I don't, a lot of these are pretty similar across those states and in Michigan, but they're not exactly the same. But yes, it will be focusing on Ohio. So to kind of tease apart those differences of what bullying and harassment are, as well as the different policies, what they look like, we're going to look at a sample policy or two sample policies. The Columbus City School, from Columbus City Schools, their Board of Education policies. They are numbers 5517 and 5517.01. Generally, I'm pretty sure it's every, at least every school district I've worked with, whether it's a small school district kind of in kind of, far outside of city and in a more rural area to, Columbus City Schools, Cincinnati, Cleveland, they all have the same number policy because most of them use board docs to organize their board policies, and those should be available on the school website. But if you would like to look at your own board policy, go to the district's website, find their Board of Education page, find their policies, and then it should be either 5517, well, it should be 5517 and 551701 that discuss bullying and harassment of students. So you can see how this might differ from Columbus, but I use Columbus because it's pretty expansive and it actually is, I believe it's a really good policy. The Ohio School Board Association uses it as an example as well of a good expansive policy for schools to be able to use. But like I said, Ohio law does outline requirements for the school district's policies, but it's the discretion is in the hands of the Board of Education when determining how that reporting gets done, how that investigation gets done, the intervention, the compliance, and monitoring bullying and harassment complaints. So under Columbus City School District, and this is going to be similar for a lot of school districts as well, the differences between bullying and harassment. Bullying is considered any unwanted and repeated written, verbal, or physical behavior, which usually includes written being online as well. And that also includes any threatening, insulting, or dehumanizing gesture as well. Their definition of bullying includes by an adult or student. So our state law was just about student on student bullying, but Columbus actually expands that to include any adults or students that are engaging in these acts as well. And of course, it has to be severe or pervasive enough to create that intimidating, hostile, or offensive educational or work environment, because it can be toward another, not only just towards students, but towards the employees as well. Or anything that creates a discomfort or humiliation to a student, or unreasonably interferes with the individual school or work performance or participation. So again, that expands the definition of bullying a little bit. And so that you don't necessarily have to prove that it's created this intimidating, hostile, or offensive educational work environment. But even if it just causes discomfort or humiliation, which is obviously a very big deal, that's enough. Or for whatever reason, unreasonably interferes with that, with the student's school participation, those can be considered acts of bullying as well. They also, and a lot of, like I said, a lot of these school districts use pretty much the same policy. It really, what really depends, or what really differentiates in the school policies I've seen is whether or not it encompasses, adult on student behavior or even adult on adult behavior. So sometimes teachers or students may feel bullied by their teachers or some other staff member in the school. Under the Columbus definition, they would be able to report this behavior as bullying if it meets the other criteria. Whereas in other school districts, the law only says that it has to be just student on student bullying. So they also have this kind of just general acts that constitute bullying or what it might involve. And again, this list is pretty much across the board for a lot of different school districts, but they have teasing, threats, intimidation, stalking, cyberbullying, physical violence, theft, public humiliation, destruction of property, it should say destruction of property, apologize, or any sexual, religious, sexual orientation, gender identity, gender expression, or racial harassment. So what conduct rises to the level of harassment? So what we really see a lot of times is that bullying and harassment, even though they're kind of lumped together in the Ohio statute, they're actually separated. They're actually separate definitions for most of our school districts, if not all of them in Ohio. So bullying, like I said, is when there's this act, physical, electronic, mental act that causes severe a severe or difficult hostile environment for the student and is sufficiently pervasive or persistent. But bullying, what rises it to the level of unlawful harassment is when and this is the Columbus definition, but what it usually involves is when that bullying is based on a protected class. So if there's one or more person that are chronically or systematically inflicting some sort of psychological or physical distress onto one or more students, and that bullying is based upon one or more of the protected classes. So those protected classes are characteristics that are protected by federal civil rights laws. So that would include, and I should have put a list in here. I don't know why I didn't, but that would include race, color, national origin, sex, disability, age as well for employees. It won't necessarily apply to students because that age harassment is usually dedicated to older adults. But those different protected classes, when that bullying becomes about that specific protected class or involves that, that's when it rises to the level and meets that definition of harassment. And the Columbus School bullying, or the Columbus School harassment policy, which again is very similar across the board in Ohio, includes any threatening, insulting, or dehumanizing gesture, use of technology, or written, verbal, or physical conduct directed against a student or school employee that places a school student or school employee in reasonable fear of harm to their person or damage to their property, or has the effect of substantially interfering with a student's educational performance, opportunities, or benefits, or an employee's work performance, or has the effect of substantially disrupting the orderly operation of a school. So again, this is both towards students and teachers as well. And you'll notice that the way the harassment policy or the harassment definition is stated, it's talking about one or more persons systematically or chronically inflicting distress onto other students or employees. And so that person again encompasses more than just students. And you will see this across harassment policies, whether or not aside from Ohio law, that it does involve if a teacher or another staff member, administration, whoever is engaged in this unlawful harassment that rises, that is based on a protected class. Since we're talking about federal civil rights law, it does, even though before I said bullying is usually limited to student on student, unless there's a policy like Columbus has expanding it to include adults as well, harassment generally does include when it's student or an adult that's engaging in this behavior on another student or adult. So some other things that are considered harassment would be any threatening, insulting, or dehumanizing behavior, like we've talked about before. We've got that verbal or physical conduct that either places a person in reasonable fear, has a substantial interference with education, or affects the orderly operation of a school. And I know we were talking about disability harassment and special education students, so that'll be kind of a highlight of today, but because a lot of these will overlap sometimes. A lot of our students aren't just can be part of more than one protected class. Sexual harassment is, any verbal or physical conduct of a sexual nature that interferes with the educational performance or creates that intimidating, hostile, or offensive learning environment, or interferes with the ability to learn. And it's really important to know that as well. And really, a lot of things can fall under sexual harassment. It can include, starting rumors based on sexual remarks. It can be, promising that something is only going to be given to you if you engage with a sexual act. But the sexual harassment is a very broad definition, and I could probably do a whole other PowerPoint on that as well, but I did want to touch on that because it is something that students, whether or not they have disabilities, will face. Specifically, disability harassment, under that policy, and again, generalized throughout Ohio as well. Prohibited disability harassment occurs when there's any unwelcome physical, verbal, or nonverbal conduct that is specifically based upon that individual's disability, and occurs when the conduct has the purpose or has the effect of interfering with that student or individual's educational performance, or has the effect of creating an intimidating, hostile, or offensive learning environment, or interferes with one's ability to be able to participate in or benefit from their class or their educational program or activity. And so that's that specificity of what disability harassment is, as opposed to bullying, is that such harassment occurs when the conduct is directed at the characteristics of a person's disabling condition, such as negative comments about speech patterns, movement, physical impairments, or appearances, or anything like that. And I will say it also can be based on a person's perceived disability as well, not necessarily whether or not they have a specific diagnosis. If they are perceived of having such diagnosis, then and they are there is that unwelcome physical, verbal, or nonverbal conduct that's based on that perceived disability, that can be considered disability harassment as well. So other violations of the anti-harassment policy that aren't necessarily specifically related to engaging in the act, that the board is required to have under state law, and also that they are required to that they're required to have under state law, and that Columbus outlines here, and that you will see again across different school districts in Ohio. The board or the district has to take immediate steps to impose disciplinary action on any individual that's engaging in any of these listed acts. The first is retaliation. If for whatever reason the complainant, which I'll use a lot, complainant, for someone who files a complaint of bullying, and then there's respondent or aggressor or perpetrator for the person who's engaged in that bullying and harassment. Anyone, if they are retaliated against in any way, for making a report, or if they've even just participated as a witness in an investigation, say Sally made a report against Susie, and Sally names Jen. I'm just like throwing names out here. Sally names Jen as her witness, and Jen participates and said, yeah, I saw that Susie was bullying Sally, and then Susie starts bullying or harassing or retaliates in any way for, tattletaling or whatever you want to call it. It's not tattletaling. What she's doing is participating in a harassment investigation, and she's protected from that as well. Disciplinary action must be imposed if anyone files a malicious or knowingly false report or complaint of unlawful harassment. And we saw that in the Ohio state statute. Deliberately making false reports is absolutely prohibited, and punishment must be the district should impose punishment on those students or employees or whomever is making those deliberate knowingly false report or maliciously false report. And then there's also a section that the district must take immediate steps to impose disciplinary action on individuals that are engaging or individuals that are failing to engage with these bullying and harassment reports. If there's employees that are totally disregarding reports or failing to investigate adequately, or there's any delay in the investigation purposefully, when part of their responsibility and is reporting or investigating, then the district is required to take immediate steps to impose disciplinary action on those individuals. And I will get into a little bit of the schools requirements and what employees are required to do in terms of reporting and investigating in a little bit. But I first wanted to talk about the different types of reporting that we have for bullying and harassment. And I just want to check the time. Okay. We have anonymous reporting, we have informal reporting, and formal reporting. I tripped over my words. It's a Monday. Anonymous reporting, it certainly can be helpful, but it has its limitations. You can submit this kind of report anonymously. It means, submitting without identifying the person who's making the report. It's usually used when the reporter fears retaliation, even though it's prohibited by the policy and the district has to impose punishment. It still doesn't, just because there's a policy doesn't mean a student or employee won't engage in retaliation, just like the fact that just because there's a policy saying there's no bullying or harassment allowed doesn't mean that it's not happening. That anonymous report can be made verbally or in writing. And details are still expected when making this type of anonymous report. They want to know the who, the what, the where, the when. But a school cannot always guarantee a full investigation or resolution, just due to lack of follow-up, not being able to follow up with who reported it because it'll be considered anonymous. But the school will still take reasonable action within the legal and due process limits that they have for the other student. In terms of informal reporting, there's more flexibility and might feel a little bit less intimidating when you take this route. You're making a complaint, but that your name is disclosed, but you're still outside of that formal process. It's a complaint that's often made verbally to any trusted staff member. And when that's informally reported like that, the staff member is required to document it in writing and forward it to the building principal or designee for review. And at any time informal reporting is done, it can be escalated to the formal process at any time. However, if in an informal reporting, I'll say, even when the complaint is made with their name disclosed, they can still request confidentiality that it not be shared with the other student, but that still kind of limits the investigation if you're requesting confidentiality because they don't want to, going through the investigation, it'd be hard to gather more information if they aren't able to share who is claiming these things that happened, if there were no other witnesses and it's going to give up, kind of compromise you and put you in that situation of possible retaliation. And then we also have our formal reporting process, which is a detailed written or oral complaint that has the full information necessary for a bullying and harassment investigation, which is the identity of the individual believed to have engaged in or be engaging in that offensive conduct, harassment, retaliation, a detailed description of the facts upon which the complaint is based, a list of potential witnesses, and the resolution that is sought by the person complaining. This gets filed with staff, administrators, like the building principal, or a compliance officer, which is usually when it's related to harassment, being that bullying based on a protected class. This will trigger an official investigation, and it will ensure that there's documentation, that you get updates, and that there's follow through with whether the bullying harassment gets substantiated and whether there's some sort of punishment or victim protection strategies as well. And like I said, it may result in disciplinary action for that other student or person. perhaps some policy changes or support services for the victim. And then the responsibilities of the school staff under this policy, and really generally what the school staff responsibility should be, is that every complaint must be taken seriously. And there's a requirement to, even if it's a verbal report that was made, there's a requirement to document those informal or anonymous complaints. It's also required that any formal or observed misconduct is reported to the school principal or designee within 2 days of witnessing. And then, of course, there's a responsibility to support the student who's alleging that they're a victim of bullying and harassment. So what happens after bullying or harassment is reported? Well, the complaint is to be reviewed and investigated. Interim safety and support measures may be provided in the case where a victim might need that potential support measure if they need. I'll kind of get into some more of those protective strategies, but maybe an oversight in having an extra teacher in the hallways to make sure that the student is safe, or maybe a morning or daily check-in to make sure the student is feeling okay at the beginning and the end of the day. And then, of course, when appropriate, the outcomes are communicated, and I'll say it's usually not only when appropriate, but if you do file a formal complaint, you will get a written document back from the school district that says whether or not the bullying and harassment has been substantiated and what steps have been taken to hopefully resolve that, protect the victim, and sometimes can, without implicating FERPA so much, can report whether or not the student has been disciplined or if there's been any formal complaints that have disciplinary or legal action involved with them. So just a quick overview of when to use each reporting method. If you're concerned for safety or privacy, then that would be when you use an anonymous reporting measure. For informal, I would say that's more appropriate if you're unsure of whether it's bullying and harassment, or maybe you're just kind of seeking advice or support. But if you're ready for an investigation and a resolution, that's where I'd go with the formal. And honestly, a lot of times, I think even if you're unsure, I would still document it as a formal complaint of bullying and have them investigate and just determine whether it's been substantiated and whether it meets the definition. So tips for drafting a successful bullying and harassment report. I would review and cite the school district's anti-bullying and anti-harassment policies. Like I said, you can find them on the school's website, and it's usually policy number 5517 and 5517.01. If not, usually you are able to search through those policies, and you can put in a search term, just type in bullying or harassment, it should pop right up. The big tip that I have is, especially for parents, is to document the complaint of bullying and harassment in writing. There have been many, many times that I've had a parent come to me and say that their child has been bullied or harassed, and that they've gone to the school and told them about it in person, or they've called someone and told them about it. And when I go to the school, all they say is that they have no record of any bullying and harassment complaints that have been made by the family. And even though I did say, and the policy does say that they are supposed to investigate, most policies again do say that if it's informally reported verbally, it still needs to be documented. A lot of times that's not happening. So I really urge parents to make sure that that complaint, whether it's formal or informal, gets documented in writing. I definitely appreciate sometimes it's good to have a conversation in person or on the phone, but what you can do after that conversation happens is follow up with the person through email. Hey, I thank you for, discussing this issue with me. I just wanted to, send an email just following up and reviewing what we talked about. I told you X, Y, and Z, and you told me this, but that way it's in writing. And if there's any continued problems, you can go back and say, well, I sent this email and we had this conversation and here's the documentation of it. If you do want to make sure that an investigation occurs when you do send in the complaint. A lot of times, again, an email is really good because it's in writing. And if it goes to the right person, that's great, especially because, but the other issue with email that I've seen before is sometimes it's gone to spam folders. Sometimes it goes to a spam folder. So just making sure that the complaint is titled, or the email's titled, or whatever document, letter you send, physical letter you send in is specifically referred to as a formal bullying and harassment report, will make sure that it gets investigated. Being specific is super important as well, and just including as much information as possible so that the district can do a full investigation, that who, that what, that where, that when of each incident, dates that you have, any potential witnesses, any piece of information that you have about the situation is helpful to the school so that they can substantiate those complaints of bullying or harassment and provide appropriate outcomes. Um, I'd also recommend that if the victim is, nervous at school, or obviously there's any effect on the student of this bullying and harassment, which is more much more often than not, and pretty much almost any time, definitely requesting a specific safety plan for the victim. And I'll talk in a little bit about what kinds of things you can request in a safety plan, but just making sure that they continue to be safe at school. And then, of course, knowing your resources and knowing the appropriate person to submit that formal bullying and harassment report to will be important. And that's in your district policy, whether it's the principal or the compliance officer, or some other staff member. So investigations, under the school policy, the principal is required to promptly investigate all complaints. Investigations really typically involve doing an interview with the student who was bullied or harassed, interviewing the alleged aggressors, talking with witnesses, whether that's students or staff, reviewing camera footage if there's any text messages or social media or any other evidence that is provided or that they have, and then potentially also consulting disciplinary records if applicable, to see if there's a pattern. Or to see if maybe they've already been punished for some certain behavior that they didn't realize at the time had an effect on another student. How long does it last? The policy and the law usually say promptly, but that doesn't really, it doesn't really give us a deadline necessarily for bullying reports. Usually I would say, and begin the investigation as soon as possible within the week. And then, of course, sometimes the investigation might take some time if maybe there's a staff member who's out sick and they're not able to meet with that staff member to get their statement, and it might take a little longer, or the aggressor is out, or the student who was bullied was out. Some of those things can cause some timeline, but within a few weeks you should receive a response. And that response looks like a written report that includes findings of fact, a determination of whether acts of bullying or harassment were verified, and a recommendation for intervention. The person who complained will be notified of the findings and whether remedial actions have been taken, while still trying to protect the offender from their protections under FERPA related to discipline that they've been given. And of course, if the acts are substantiated, the complainant will also be provided with support and protections.
Renee, we got another question.
Sure.
It is, how does free speech, especially online and off-school grounds, impact these investigations and reports?
So students, and this definitely could be a whole other topic, and we're actually going to talk about it at our student rights conference, which I should have mentioned at the beginning, but we will be having AW will be having a student rights conference towards the end of July, I think, or middle of July 17th and 18th, and we will have a presentation on free speech. But students' right to free speech in schools is limited. There can't be anything that disrupts the educational environment. And essentially kind of what we've seen in these definitions are that bullying and harassment causes a substantial disruption to that student's educational environment, so they don't have that same free speech protections. In terms of, it gets a little trickier when it's outside of school, and when we're doing it online. I mean, if it's online during the school day, there's probably some jurisdiction, but what we're seeing again is for off-campus speech, perhaps, there's bullying that is engaged over I don't, are kids even using Facebook these days? Geez, on Instagram or TikTok or whatever we're using these days. If there's some bullying, what it really comes down to is what the effect of is on the student at school. And if it is disrupting their learning environment at school, maybe they're, again, because of what the student is threatening, after the student after school goes home and receives a threat that they're going to get hurt at school, or they're telling them that nobody likes them at school, and then it interferes with their educational environment, creates a hostile educational environment, interferes with their ability to learn. That's when the school can have that jurisdiction over that, but over that type of off-campus speech. But really, the free speech is limited in certain areas, including like jails or public buildings, but schools as well do have limited free speech protection. So when it does create that hostile learning environment, that's where free speech is not protected. So hopefully that answers that question. And you can learn more if you come to our student rights conference in July too. So I will move on to investigations of harassment reports, which again, because the harassment reports are related to protected classes and fall under federal civil rights laws. There is a little bit of a different, I mean, the investigation is essentially the same, but the timelines are a bit, are more defined in these cases, as you'll see. The formal investigation has to be initiated within 5 to 7 days. The alleged perpetrator or the alleged aggressor will be informed that a complaint was filed, and the aggressor will have 5 days to respond to those allegations. The goal is to have the investigation or harassment investigation done within 15 days. Again, if someone's on a vacation or they're trying to review video footage or get other evidence, and for whatever reason they can't get that, that's when that might be extended. But again, it has to be in that reasonable time. And then in those cases, instead of the principal, it'll be the compliance officer that'll prepare a written report that goes to the superintendent that summarizes all the evidence that's gathered and also provides a recommendation using a preponderance of the evidence standard. So it'll say, based on a preponderance of the evidence, the act of harassment was substantiated or was unsubstantiated. And then the superintendent will be the one to issue the final decision on whether there was discriminatory harassment or retaliation within 10 days of receiving that report. So just a couple examples of what might be unsubstantiated for a report. Maybe it's when both students appear to be in violation of the policy, both students involved, we hear both students involved are at fault, they were doing it to each other, he started it, or the other one started it first. Sometimes it'll be he said, she said scenarios. If there's, limited witnesses or evidence that's provided. The offender didn't confirm the victim's allegations. She said she didn't do it. She confirmed that she made the statement, but it was directed towards someone else, not the victim. Or the definition of bullying or harassment just isn't met. The bullying, for example, if the definition in a school's policy for bullying is that it was an adult, is that it's just student on student and it was alleged against an adult, then that would be unsubstantiated, as well as if it was only one act and it wasn't sufficiently severe or pervasive, well then if the bullying wasn't repeated by the same student or group of students, then we haven't met the definition yet. For those that are substantiated, some intervention strategies for victims of bullying and harassment would be involving the student in the decision-making about their support plan, so that they feel that they have some control and input into that. And I would definitely do this in the form of a written safety plan if possible, so that everyone's aware of it. The offending students should be supervised and disciplined fairly and consistently. Some other strategies, again, it depends on what the student wants and what what's best for their safety, but perhaps it's providing adult supervision during unstructured periods like recess and the hallways at lunchtime, maintaining contact with parents and guardians of all involved parties so that everyone's aware at home as well, so that if there is anything that's going on off campus, that can stop. Informing other school personnel of the incident and instructing them to monitor the victim and the offending party. And then some additional intervention strategies would be assisting the victims to obtain counseling or an assessment for counseling if that's needed, checking in with the victim daily to verify that there's been no additional incidents happening. And then sometimes it's even separating the student from the aggressor, changing classrooms, changing schools, without treating the victim like they are the problem. This is a little bit harder to do, but in some of those more severe circumstances, this can be done. In some schools, I know Cleveland Metropolitan School District does have a policy about moving students out of the classroom or out of the school if they've been a perpetrator of bullying and harassment. Creating a written safety plan, like I said, by modifying the routes to classes, modifying any routes between classes themselves, or modifying seating to reduce the risk of reoccurrence, and then obviously adjusting the safety plan as needed based on the student's feedback. Some consequences for offenders of bullying and harassment. If the verified acts do not reasonably require a disciplinary response, the students may be counseled just as to the definition of what bullying, intimidation, and harassment is, why it's prohibited, and that it is prohibited, and their duty to avoid any conduct that could be considered harassing, intimidating, and bullying. And sometimes this can be even if the acts were unsubstantiated. If the complaint is arising out of a conflict between students or groups of students, they might consider peer mediation. And then, of course, there's in and out of school suspension that might be imposed as well, or expulsion if it's a more serious incident, or if past interventions haven't been successful. Public schools are required to semi-annually provide the Board of Education president in their district or board president a written summary of all reported incidents during that school year, or that have been occurring during that part of the school year, and then post a summary of that on their website. And then, of course, public schools are required to notify CPS of any suspected child abuse, or they are required to notify appropriate law enforcement if there's been any criminal misconduct. As far as training for public schools, information regarding the policy has to, at least in Columbus, or sorry, nope, this is not in Columbus. This is under Ohio state law. I apologize. 3313, 666, and 667. Information regarding the policy has to be incorporated in employee training materials, and the school has to provide training workshops or courses on the district's bullying and harassment policy for school employees and any volunteers with direct contact with students. Students enrolled in the district also must annually be provided with age-appropriate instruction on bullying and harassment, which includes a written or verbal discussion of the consequences of violating the district policy. Parents and guardians are also required to get a written statement about the policy and the consequences for violations every school year. And then in terms of dating violence as well, there has to be annual instruction related to dating violence for all middle school and high school students as well. So I know we only have a couple minutes left, so I'll run through this part really quickly. But I just wanted to test knowledge, and I won't even be able to see what goes in the Q&A. So maybe I'll just go through this really fast. So I just wanted to give you 3 scenarios, and I wanted to see if it would be considered general conflict or if it would rise to the level of bullying or harassment. The first scenario, a trio of 5th grade students regularly force a new 2nd grade student in school, Finn, to give them his lunch. Finn does not report the situation in fear of retaliation by the students. Is this A, conflict, B, bullying, or C, harassment? And I'm just gonna let you think on that for 5 seconds. I can't see the answers and I gotta move through this so we can be ready for our individual guidance sessions. But if you are saying in your head or said be bullying, you are correct. That would be an intentional physical act that the students were exhibiting toward another particular student more than once, and it caused mental and physical harm to the other student and created an intimidating educational environment. Here, there was that intentional verbal and physical act, asking to give the lunch, caused the student mental harm because he was in fear of retaliation. It happened more than once, so it was sufficiently persistent, and there was certainly an imbalance of power as well. Scenario 2, a classmate, Elena, repeatedly calls Tyler, a student with a learning disability, stupid or idiot while in school and on the school bus. On one occasion, Elena tackled Tyler, hit him with a school binder, and threw his personal items into the garbage. Tyler, who had been performing well academically, became angry, frustrated, and depressed, and often refused to go to school. Is this conflict, bullying, or harassment? Couple seconds to think about it before I give you the answer. And if you're thinking that is disability harassment, you are correct. Bullying rises to the level of unlawful harassment when the conduct is sufficiently severe, pervasive, or persistent, inflicts physical hurt or psychological distress, and is based upon one or more protected classes. So here, the use of insulting and dehumanizing verbal or physical conduct was happening. And it was happening on a regular basis, as we saw. Both physical and psychological distress were inflicted. It was based on his disability, and it had a substantial interference with his education. Our last scenario, Zach asked Abby to play at recess. Abby did not want to play with him because she is playing with other friends. Since then, Zach has asked Abby to play every day for 2 weeks. Abby has continued to decline and is beginning to feel bothered that Zach continues to ask her to play. Is this conflict, bullying, or harassment? Couple quick seconds to think. I'm sorry we don't have much time, but if you said this was just general conflict, you're correct. This example outlines a typical peer conflict. There may be a possible imbalance of power, but there's no intent to harm. Abby didn't tell Zach or others to tell him not to be his friend. They told, she's been polite and has tried not to, humiliate him, and she's just inserting her right to choose her friends. And then finally, just a quick note before we finish up. Great job. And then my final quick note was when to file with the Office for Civil Rights. If you believe that the Office for Civil Rights will investigate complaints related to harassment, but not bullying. So it has to be based on a protected class. But if you believe that the school has failed to address harassment based on those protected classes, or the harassment has created a hostile environment that interferes with the student's ability to participate in or benefit from school's programs, if you believe the district's investigation was unfair, incomplete, or retaliatory, or you experience discrimination in the complaint process itself, then you should file with OCR within 180 days of the last act of discrimination. You can file on their website and include as much information as you can, but you don't need to go through your school's entire process before filing with OCR. You can file at any time, but that is your resource to use if you are having any trouble with the bullying or harassment, or specifically harassment, not just bullying, issues at school. And I somehow made it right to 1 o'clock, but I appreciate everyone for joining today. I know I don't know how many questions there are. I don't know if I see any. Amy, I don't see any other questions. If you do have any questions, I just took down my email, but my email was, and I'll put it in here real quick, because we have to jump on to oh, I see one Q&A. Never heard of OCR. OCR is the U.S. Department of Education Office for Civil Rights. They investigate any complaint of discrimination based on a protected class, which would include complaints related to harassment experienced by special education students. And they have a statute of limitations, or they have a deadline requirement of when you can file that complaint. And it has to be within 180 days of the last act of harassment or discrimination. So I dropped my email in the chat. If you have any other questions, feel free to email me. I apologize for going so fast today. So then what after 100? If it's after 180 days, then OCR will not investigate. That's unfortunately the time limit. But you can still bring it to your school board if you have questions about it, but there usually is that time limit. And if there are no other questions, which it looks like, I know we've got to hop off to our individual guidance sessions, but I appreciate everyone being here today. And like I said, next month, third Monday of the month, we'll be on the science of reading. And then our law firm is also hosting a student rights conference on July 17th and 18th that you can sign up at lawyersforstudents.com/SRC. And we hope to see you there. If not, we hope to see you next week or next month. I'm sorry, at our special education legal clinic. Thank you, everyone.